Hi guys, so today I would like to talk about before you get married, should you disclose everything? And this is only applicable for clients who are planning to get married and have a prenuptial agreement. So some clients ask me, should I disclose assets, apartments, houses that I have in a different country? The answer is yes, of course. Because if your spouse upon divorce or before divorce finds out that it wasn't disclosed, he or she can set aside a prenuptial agreement. So if you have an apartment or building complex or many complexes in Russia, Ukraine, wherever, disclose it, because it's going to be separate property according to the prenuptial agreement you'll set up, but it will risk the whole prenup. The point is, don't do a prenup if you're not planning to disclose everything. That applies also to debt. So car is a debt. For example, if you have if you finance your car, that's a debt. If you have a mortgage, that's a debt. Obviously, anything that is requiring payments is a debt. If you have spousal support that you need to pay to the prior marriage, that is considered a debt because it's a liability, especially if there is a court order. If there is no court order, you're not required to do that, but you're still doing it, I would suggest to disclose it. Now, a lot of people wondering, well, can I save money on an attorney? So let's have you draft the agreement, but my spouse is not going to hire an attorney because we agreed on everything. There is nothing in dispute. So let's just skip on that because it's too expensive. I would say, and I say, I don't take those kind of clients because you pay me money for a prenup that's going to be set aside. The law requires that both parties are represented, and if one party who is enforcing the agreement is not represented and has not been provided a memorandum of understanding by someone else, who could that be? It could be only a lawyer, but I cannot do it because I'm representing the husband. I'm not going to get involved in sending memorandum of understanding to a wife when she can later claim that was legal advice or whatever. So I'm not doing that. And therefore, the whole agreement, according to Code Section 1615 Family Code, is going to be not enforceable. So that is something I strongly suggest that both parties have an attorney. So we covered financial disclosures. We covered both parties need to be represented. 7-day rule. So 7-day rule has been also litigated in court a lot. The recent law states that the final agreement needs to be untouched for 7 days prior to signing. Again, final agreement, meaning the final version. You can make changes such as typos, name, things like that, but not waiving or not waiving spousal support. That would be considered a significant change. So the final version of an agreement needs to be untouched 7 days prior to signing. And you can sign on the date of your wedding. So some people call me up and say, oh, my prenup is not valid, so I can set it aside because I signed it on the day of my wedding. Did you have 7 days before you signed it to look at it? Yes, at a final version. And if someone presents the agreement 7 days before wedding, of course it's not valid because you had no time to negotiate it. I'm talking about final version after negotiation, after you had a lawyer, that type of 7 days, not the initial presentation. So ideally, I would suggest to start working on a prenuptial agreement 3 months. You don't want to sign it on your wedding date, right? You just don't. I mean, it's not romantic enough. Although I really like conversation about money prior to wedding than after, because things come out that might need some work. before getting married. But yeah, so that's my suggestion, to talk about money, talk about finances, who's responsible for what. Some people try to put micromanaging factors into a prenuptial agreement, and micromanaging, I mean, this is how much we're going to put into prenuptial agreement. For example, into joint account. So I don't like prenuptial agreement that say, oh, I make $1 million, you make 100,000, and we put 50-50 to our joint account. Really? Are you going to go in, if the other side who makes 100,000 suddenly is not putting 50% according to this prenuptial agreement, are you going to sue them in small claim or what? Or what are you going to do? Or upon divorce, are you going to say, oh, look, last 10 years I put 50%, but you didn't put anything, so I get reimbursed? I mean, this is the type of micromanaging of life in marriage I really ask my clients not to do. Also, prenuptial agreement is designed to discuss finances upon divorce, not during the marriage. It's not a living document that can be, it's when people get divorced, we look at the prenuptial agreement and say, who waived what about spousal support? We cannot talk about children. It's against public policy. We cannot say, well, if I have 3 children, then you're not going to pay child support. That's not acceptable. Custody-related agreements are also not acceptable. Even if the children already exist, it's not acceptable. Because custody agreements can always be changed. So we can put some provisions regarding custody, but the other side can always come back and just say, I changed my mind, and the court will allow it. Child support, same thing. So I don't suggest putting anything in a prenuptial agreement regarding children. So we talked about disclosing everything before getting married. We talked about getting lawyers on each side for prenuptial agreement. And we talked about what to put in or not. One thing we also don't put into prenuptial agreement is penalty clause. If you cheat, I get $50,000. So I'm going to prove that you cheated. First of all, California is no-fault state. No fault meaning I can get divorced even if you didn't cheat. So I can get divorced for whatever reason. It's called irreconcilable differences. It has been abolished. No more dirty laundries, no more drama in court, no more mistresses on the stand. It's all gone. Or I should say mistresses or lovers, male lovers. Anyway, so it's not the point. No penalty clause because it would be considered against public policy. Also, how will you prove it? Will you call the mistress and ask to, or male lover and ask to testify and say, yes, we had this, you might not even find them, and they might not even, it's just, no, prenup doesn't include that. And some people want to include it, and they might abide by it, but technically it would be not enforceable. All right, so finally, and we talked about 7 days, right? So 7 days prior to signing, just final version. Now, fairness. This is a big topic. Prenups are very difficult to set aside, but not so much if the factors I just described are violated. No 7 days, no lawyers, no disclosures, easy. As a matter of law, can be set aside. Easy for the judge to do. Everything else becomes a little more complicated. For example, if the other party who had a lawyer to defend the prenup was the best buddy of the one who drafted it, then we get into the topics, well, was it really independent counsel or not? That could be already dicey. Then another question is, what if the spouse who drafted paid the lawyer directly of the defending spouse who reviewed the agreement and gave instructions? Well, technically, the lawyer ethically is not allowed to take instructions. And if that happens to me, where the other side is paying me, I ask them to waive, I ask both of them to waive a third party, what is it called? It's called third-party waiver. Basically, they cannot influence me. Just because they pay, they cannot give me instructions. They cannot get confidential information about the client who's actually my client, who's technically being paid by the other side. So I usually say, in order to avoid all of this, just have the spouse who is wealthy, who is trying to protect assets, pay the client who is hiring me directly, and the client who is then paying me directly. So that's that. Fairness. A prenup, although it's difficult to set aside, it's got to be fair. And the definition of fairness is for everyone different. It depends on the case. If someone is zillionaire, millionaire, billionaire, and the other side is not, and the one who drafts the prenup says you get nothing at all, no spousal support, no division of assets, most likely this prenup is going to be set aside. If the difference in incomes and assets is not that different and they just separate everything, that's fine. But if at the time when the prenup is drafted, they're sort of semi-equal, and when I say sort of semi, I mean 100, 200,000 in income a year difference is not that big of a deal. It becomes more when it becomes in 3, 5, 4, 400, 500 million type of difference. And at the time of the prenup being enforced, meaning let's say when you agreed to sign it, equal income semi, but then at the time of divorce there is a huge difference, then the prenup could be set aside because the judge has the authority to say that it's unfair. It's called unconscionable. Complicated word, Family Code Section 1615. Doesn't matter, but the judge has the authority to set it aside. Recently, which is very scary and I really don't like it, the judges set aside only one section that says spousal support waiver, meaning if you agree we're not paying each other alimony, the judge doesn't care. If one spouse needs the money, the judge will award it. And it happened to my colleagues. It happened to me. Thank God I was representing the client who needed the money. But I really don't like it. So in my recent negotiations, I tell my clients, look, just give at least something than nothing, because it will be a contract and it's going to be enforceable. Now, we get into immigration. Immigration becomes a very interesting topic because when a spouse who is sponsoring another spouse will sign an affidavit of support, 864, I-864 form, which says, I'm going to pay you, if you fall under government's support, 125% over the poverty level. Now, what's the poverty level? 15,000 right now? I don't know. We got to look it up. So 125% of that is not much, maybe 20,000 a year. And if we waive that in the prenup, California case of appeal called Kumar, Kumar, states that this affidavit of support, although it's federal law, has nothing to do with the state, is a contract. Think about it. It's just like doesn't make any sense, but it exists. This case of appeal exists, where a spouse who waived spousal support in a prenup comes to family court and says, but hello, I'm going to get this 864, 125% because it's a contract, Kumar case, please give me the money. And there is no expiration date, by the way, for 864. It can go as long as, and one judge, Judge Frankie in San Mateo said, well, but you got to be self-supporting. I'm terminating I'm going to say, well, the spouse support is going to terminate. And appeal said, no. There is no, this contract, this form, affidavit of support, does not have a requirement to become self-supporting. So I hope that Kumar case get to the Supreme Court, because this is ridiculous. Family court has system in place, meaning if the spouse is lazy, then the court can impose government warning, sick work order, imputation of income. Kumar case says, no, the requirements to terminate that are if the spouse who is receiving it gets, for example, citizenship, one of the requirements. I don't want to go too much into Kumar's case. This case makes me get out of my skin. Okay, so prenups are, if you have lawyers, if you follow all these steps I just discussed, most likely going to be enforceable. Very, very small percentage to set it aside. But what people do who signed a not a good prenup, they hire lawyers and try to set it aside for the sake of creating some doubt in the other side in order to get a better settlement. So I had cases, returning cases, where we had a very solid prenuptial agreement, no waiver of spousal support, just, copying it. And then she tried to set it aside 3 years later when they decided to separate. And then we sent discovery, excessive discovery about committing to reasons why she wants to set us aside, and she dropped her claim because she knew there is no reason. She just filed a request for her to set it aside to create some fear, and it worked. My client settled, but when we sent the discovery, she very, very fast got off her horse and settled to a reasonable amount. That would have been the prenup amount anyway. Should you disclose health issues? Should you disclose inability to have a child if you know the other party wants to have a child? Absolutely, because prenup or no prenup, the marriage can be annulled based on fraud. So significant topics such as fertility, ability to have sexual intercourse are important topic for the statute of fraud. So make sure everything is on the table. I mean, it's obvious. If you go to marriage, you want to build it on trust, but some people, forget about it, I guess. And then I had cases where we filed for annulment. We settled because of immigrational problems that would come with it, but yeah, just make sure to disclose everything. I hope I don't forget anything about prenup. So I don't think there are any recent developments that I saw worth mentioning other than the Kumar case, which is not very recent, and the spousal support set aside lawyers. So I think that's it for today about prenups. And if you have any questions, just email me or I'll see you in my next consultation. Bye.